Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's stream, we're going to be responding to an update in the Delphi murders case, something that we've been following closely with the cult murders and the Oldenism and all that kind of fun stuff. Very exciting, right? The defense has suggested it's part of some sort of cult murder, Delphi cult murdered Odin, the god, and I'm like, okay, that's a pretty interesting theory. But there's other indicia actually that the guy might not be guilty, or at least we can't prove it based on some other indicia. So the case has been interesting because it's a little bit complicated in some of the details. Also, some evidence has been leaked related to the case, some of which was leaked by the general public, because the general public was involved in the search for the missing children that were ultimately killed. And some of the public, it appears, took photographs, and the public released information regarding that to the open. Also, the police themselves may have released information improperly as well, in violation of law. So all kinds of fun things happening here. And also, it's a little bit unclear that he's necessarily the guy, at least based on what I've seen. I'm not saying he's not the guy. I'm just saying I have questions, which is always a good place to have, right? When you don't know. So there's supposed to be a hearing that's supposed to be happening now. And assuming that is going to, in fact, happen, I'd like to cover it with you because that's kind of how I roll. So I'm just waiting to see if this thing actually pops up, because my mod told me 11 a.m. Eastern time, and I'd like to take note that's now. So I'm just trying to see if this thing is actually happening. So if not, then we'll talk about other things, I guess. How are you all doing while we're waiting? I hope you're doing great. Yeah. Guys look very blue. That's very nice of you. Thank you. How is it in counsel's latest motion? They argue old defense counsel regarding conditions at the prisons. Yeah, I don't have any particular issue with that. Yeah. Destiny's banned, and they might ban you for talking to him on Twitch. I'll try to take note of that, I suppose. I'm certainly not trying to circumvent. I'm just having a conversation, but yeah, I know that can get tricky with that, but fair point. I'll keep that note for the future. I suppose I'll delete it from the archive just to be safe from Twitch, but I'll keep that note for the future. Again, I don't know a lot about the guy. I looked up his bio like last night sometime, and I noted he was suspended from Twitch, but I didn't know that at the time. So yeah, I'm just trying to see where this thing is actually happening or actually being covered. I had a great conversation last night with Pisco. That was a fun conversation. We had a good time. I look forward to talking to him again in the future. I found him to be a good faith interlocutor. We wound up disagreeing about some things, but I appreciated. Oh, here it is. Is this the one, Richard Allen? I got it.
And his license.
All right, cool. I found it. We're 2 minutes behind real time. No problem. I'll put it on screen. Oh, Crime Talk has it. Lol. I'll borrow it from Crime Talk. That's fine. Stop streaming. I'm busy over here. We're 2 minutes behind real time. Give me a second. We'll get there. No muss, no fuss. We'll steal it from Crime Talk with Scott Reich. I like Scott too. I don't think he'll mind me stream sniping him. All right. All right, so this is the hearing of Richard Allen relating to the Delphi murders. Oh, man, good times. All right, let's watch this thing. We're about 3 minutes behind real time, but we'll play it live because 3 minutes is 3 minutes. Who cares, right? All right, let's listen to this.
Today we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnicky.
Check 1, 2.
And Bernice Corley.
My audio is a little low.
Bernice Corley. Representing the state of Indiana council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right.
Okay, the audio is really, really echoey. I hope this gets better.
Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. In a council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and council.
Yeah, the echoes in
Council
the
has been
original. There's
conducting
nothing I
oral
can do to
arguments.
solve it.
We
We're just
have
stuck
about
with
2
it,
minutes
guys.
before we may start asking questions.
We're stuck with the
Each side has 30
echo.
minutes, so
Learn to
you're ready
live
proceed.
learn to love the echo. The echo
All
and
right,
you are going to be
Mr.
friends
Lehman.
for a while. Yeah. Learn to love the echo. You're going to be good friends for a while.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that the court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review, this implying the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier
That's the wrong
of
argument.
neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's
No, not without
So
jurisdiction, without power.
More accurately phrased that she's under a duty to let them back into the case. It's not a question of the court's jurisdiction being exceeded, is it?
No, it's
No,
not.
Judge, I see those as one and the same.
Are you talking about
Do you?
authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as
It's authority,
the
not
judge is
jurisdiction.
without
What are you talking
authority,
about?
or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these
Okay,
circumstances.
so, but you don't cite a lot in that. So when
Okay, well, the court apparently is in recess 2 minutes into the oral argument. I guess that was exciting.
Fully understands that whether he's making a knowing and voluntary
and
decision.
the
in that
absolute
regard.
duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this, constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserve that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple, you've got a lot of concerns and you do a nice job laying those out in your brief, but there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr.
Refile? You never filed it in the first place. What do you mean refile?
Attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
Process is the answer.
Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But
process.
Third,
say it.
Issues don't involve.
If there's not a record.
Say the word.
The findings
Damn it.
are proper. But if the findings are correct, why doesn't what she did follow?
Process is the answer.
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happening. I'm ready to ride or die with these lawyers.
I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen.
Oh my God.
Judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am.
The answer to the question was yes, by the way.
That by proceeding forward, that could cause some problems for you, and he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But
this isn't a conflict of interest
because the judge didn't hold a hearing.
This is the lawyer's
incompetence. The judge didn't hold a hearing and say, listen, I feel like this pretrial
You're waiving your right to effective assistance of counsel.
A year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about
damn straight
ineffectiveness.
Yeah.
That's what I said.
None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so
Yeah,
if we were to agree
I'm
with
slightly
you on,
surprised you're hearing the case at all, to be quite
standard
honest.
arguments that you've made, why is it that the regular appellate process
That's a
is
really good
fully
question.
inadequate?
Why is the Supreme Court hearing this case? That's a good
Justice
question.
Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to.
Why?
My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on the
Justice
back.
over here on the
And it
far
was
end is like,
blown out
why
of
the hell are
water
we
from
hearing
the
this
judge who
case?
exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge.
I'm not
asking for an
particularly
extension of
impressed
time.
with this advocate's
gentleman
polish
had
level.
Attorneys Bolden and Rosie, who he'd
You would
been
think you'd
working
get
with
better from
for
the state
over a
Supreme
year to
Court, but
develop
apparently
and get
not.
ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Got a
those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial
There's some evidence of incompetence
which
right
is
about now,
My
I have
concern
to
is getting
say.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's a structural error and it'd be reversed and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer.
No, it's really not from your frame. It's either absolute or it's not, you
filing briefs,
jackass.
Not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases.
This is none of those things.
And so, like, if a
this is
lawyer
none of those
in one case
things
was obstructing
This
justice,
isn't the
he
lawyer
literally
withdrawing.
behind
It
the
isn't the
scenes talking
client
to
saying
co-defendants
go
who are
away.
represented, trying to
This is the
manipulate
judge
their
telling you to
testimony.
go away. What are you talking
The
about?
judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer—
You should have rooted it in process,
the
man.
defendant to take
This is
the
the wrong
plea
line of
because for
argument.
fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way: if we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't— it depends on what record the court would build regarding those, but no, I'm going to change that yet, Justice. No.
You're going to change what the justice said? Oh, that's good.
With effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity, and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
Well,
yes.
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did,
No, sorry. The reasons that she advances aren't reasons to find a lawyer.
But even if they were,
Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point, and
Oh
he
my
was
God.
fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant—
yeah, I don't think that can be the right answer.
says,
I was
"I wanna go
skeptical of
forward,
this
I've
in
been
your
fully and fairly
briefing.
advised of it," and the judge somehow has a role absent of
I was
conflict of
skeptical.
interest.
He's like, these are the
injecting
only reasons a judge can remove
And I do
someone in
think you
Indiana. I was
can
like, I don't think
waive-
that's true.
You can.
I know you said it a lot,
Ineffective assistance.
but when I read your
counsel.
briefing, I'm like, I don't think that can
That's-
possibly
that's
be true.
Well-established case law. It's just
The
none
Indiana
of these
Supreme
things
Court
the
doesn't
judge
seem to
cite
think
have
it's
anything
true
to do
either.
with ineffective assistance of counsel. These are purported ethical violations, and not
Yeah.
every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. In that the inadvertent disclosure of pretrial discovery has not, the alleged violations here would have nothing to do with the trial strategy
Oh my God.
that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear.
Are you going to try to save him?
The trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them, they just weren't adequately reflected in the record?
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found, would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly
I've been
aware of
spoiled
those
by
proceedings
Supreme Court
and
oral
still wants to
argument. That's the
proceed forward
problem.
with these clients, then there's the judge has
Apparently,
absolute
Indiana
duty to
Supreme
accept
Court is not on the level of
act
a
on his
U.S.
wishes.
Supreme Court.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could. Because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Woof. Woof.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing Respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief in the trial court. Court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits,
So they're both extremely normal and extremely rare.
Raises
Okay.
a pretrial constitutional violation, you will be flooded with these kinds of actions.
So your
Counsel, you
solution,
think that counsel's, Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so I'm
violation.
clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What
He has a point.
about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
but it has to be done, there's a way that you do it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her
There was a
authority
hearing
by
in
the
chambers.
manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of
So there's
procedure.
no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled.
Yeah.
Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case
They didn't really have notice of a
made their
hearing.
own strategic decision to
They didn't have
withdraw
notice of a hearing.
rather than go out in
As it
open court
happens.
and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And
In other
they had
contexts.
noticed that the judge was considering disqualifying them. They had noticed on October 10th, when the judge told them that she was considering disqualifying them, they were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So, which means,
Well, we won't know
do
what
know
would have
that.
happened at a hearing that never happened, but you're right. I mean,
The justice
I
disagrees with
certainly
you.
acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you
and
help me
attorney work product.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that
It was a major
conflict.
conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't see
himself,
Wheat as tucked as neatly as you find Wheat. So
Wheat
go outside Wheat and give me something else.
well, but again, Wheat himself claimed
That was the wrong
this
answer.
conflict was highly remote.
That was the wrong answer.
Highly unlikely
The judge
to
just
occur.
says wheat didn't work. Try again.
Small chance.
Did you think about wheat?
And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on
where can you point to me saying, with regard to saying somebody is incompetent or negligent? That's like, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed
Damn
the
straight.
dissemination of information regarding
Good
the
question.
crime scene. So can a judge disqualify the prosecutors too?
Well, again, The judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not
that's
suggesting,
true as far as it goes.
nor is Judge Gull suggesting that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, you know, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was
He wrote a letter to that effect, exactly almost those words.
And then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense.
What?
I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honor.
Gutwein.
Okay.
Ms. Sanchez.
Ms. Sanchez, do you have anything intelligent to say? Woof.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen's counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself.
What would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Massa suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process.
Well, she's doing
Trial
better.
courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have
I'm not sure what's confusing about that, to be honest.
Allen is, or what he wants, what he knows, what he understands is, of course, secondhand.
No, we've got some firsthand stuff, to be honest.
Aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice.
I think we have that down, with all due respect, counsel.
There's been many consistent allegations.
He wrote a letter.
Throughout the case, and then of course
I'm totally aware of what you said that my lawyer did. Here's exactly what you said my lawyer did. I don't care. Please let them be my lawyer. I'm not sure what's ambiguous about this.
Concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it.
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play.
I'm not sure that was an
when
answer to the
deciding
question.
how to balance all of the concerns for a fair trial, for his representation, to the all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below.
That's kind of the problem. It isn't
it's
fully explained
reasonable when
because of the
looking
abbreviated
at if
proceedings.
that
That's
is in
sort of
fact
the
what
problem.
judge means. I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the
I would have
effect
ruled this
of
whole
their
thing in
performance
process from the
on
defense.
the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one
I
of
would
those
have rooted in
incidents
substantive and
itself might
procedural
not
due
be,
process.
But there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it
but-
could be conflict, it could be.
She could use a little bit of confidence in her
the
life.
judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm
in these
clear,
cases.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? Is that?
Did she say anything?
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, Please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking
Damn
of
straight. Good
sensitive
rebuttal, at
information in this
least.
case.
Thank God.
I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's
We have
on
it.
page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys
Good answer.
Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which
Good
is
answer.
to give you
like it.
zealous advocacy for your client.
All right.
Gentlemen, when faced with a real tough
Pick it
call,
up on the back half,
financial
counsel.
tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The attorney general and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order is
I'm liking this.
on the same level as
Good rebuttal.
conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Massa and Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But Absolutely, a defendant could waive a claim of ineffective assistance to counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance to
I
counsel
like that
claim.
answer too. It's very direct.
You can, so if a client wants to represent himself, he can waive his right to effective assistance to counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance to counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice prong. So, but yes, if these things could ever arise to ineffective assistance to counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here.
Okay.
In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's.
Jurisdiction is the wrong word, man.
Duty to act upon
It's
them.
not jurisdiction. That's the wrong word, man.
I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's.
I don't think that word
They
means
are
what you think it means.
undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right.
I can't say that I have a very high opinion of the room that the Supreme Court meets in. It looks halfway put together like it was done on a stage for a play.
Ladies and gentlemen, this courtroom will be exited in a orderly fashion. Start with the first 3 rows on the either side of the podium.
All right, that's the end of the hearing. We don't need to listen to the marshal say whatever he's going to say. We're good. All right, so let's talk about what happened because there was a lot that just happened. All right, so let's talk about this and what happened. All right, so let's start at the beginning, I suppose. So the Delphi murders considers this guy Richard Allen. Richard Allen is the primary suspect and is the person charged with the death of two teenage girls. I'm not sure, strictly speaking, they were teenagers. One of them might be 12. They're young. Whatever. They're like 12 or 13 or 14. So something in that age range. Okay. 2 young girls. Let's just go with that. All right. Anyways, he's charged with this murder. And there is some evidence against him, to be sure, but not a lot. And some of the evidence that's against him seems very questionable. For example, like tool mark identification because of the weapon used is shaky. Like there's, at least that's been released publicly, and I can't speak to what the state knows. But based on the information that's available, which of course is all I can adjudicate on at the end of the day, right? Based on what we know, it seems like a very, very thin case. That may or may not reflect reality, but it seems thin, okay? At least to my mind. Now, his defense lawyer at one point had suggested that these were ritualistic murders that were done by people in the name of Odin, which is one hell of a defense theory. Because, like, how do you come up with that idea? I don't know. But whatever, right? All right, so he has 2 lawyers who are appointed to him. They're appointed to him by the government. They're court-appointed counsel. And they're going about representing him as one does. And there were some things that happened along the way. Now, as memory serves, I think it only was one of the 2 lawyers who had any problems. I think the other lawyer didn't have any problems at all that I remember. But the one lawyer who did have a problem with the 2, he had sent effectively like a table of contents relating to privileged information to someone who wasn't entitled to receive it. And, you know, not, it's an oopsies. It's a notable oopsies, but it's a table of contents, right? So it's not like the information. It's meta information. So it's not great. It was sloppy. It was a mistyped email, but it's not like a huge deal. I mean, it's a notable deal, but not like a huge deal, all right? The other thing that he did that was sort of notable is there was a gag order as it relates to the evidence in the case, which of course is not atypical, right? You want the evidence to be in trial, not everywhere else on the face of the earth, right? You want the evidence to be presented at trial or not, as it may be, depending on the rules of evidence, right? So there was a gag order that required the attorneys to keep the information confidential. Our hero to the cause over here, the one attorney who did the email thing, also was keeping said documents in a conference room that was unlocked in his office. A guy who worked for him in the past and may or may not work for him now, was a little ambiguous on this point, but he seems like a contractor, right? He seems like a contractor at best. So he definitely wasn't working for him on this case, which is enough, incidentally. So he was working for this guy full-time in the past and maybe working for him on some sort of contractor basis now. This guy who apparently has, this random guy who apparently has a girlfriend in the area of the office of the attorney, just stopped by the attorney's office one day to say hi because, they're friendly because they knew each other from working with each other and stuff. So he stopped by to say hi. In the process of doing that, he went into the conference room. He saw the information, including like pictures from the crime scene. He took a picture or pictures of the evidence, sent it to a friend, who sent it to a friend, which leaked it to the media and social media. So this is a pretty big oopsies, right? This is a pretty big oopsies, right? This is why you keep information confidential and close hold. For exactly this reason, right? Because you don't know what happens once it gets out. So you send it to a guy who sent it to a guy and it leaked on social media. Fantastic. Now, it has certainly been said that the government might have also leaked information. The degree to which that's true, I can't really speak to, nor is it really relevant to me as I'm trying to do the analysis, because of course I believe in the rule of law and I believe in it universally. So me saying, well, what about the prosecutor would actually be a whataboutism, right? I mean, that would actually be a whataboutism because I'm not trying to use it to define the category. I'm trying to say instead, well, this guy wasn't punished, so why punish this guy? That would be whataboutism, as we're trying to delineate what is and is what not whataboutism. So whether the state did or did not leak evidence, I really don't care for the purposes of this exercise for the moment. It's enough to simply say, I also don't care, incidentally, even if the information that he leaked was already leaked. Because it's sort of like classified information for anyone who knows anything about classified information. Just because a classified document is in the open doesn't stop it from being classified, right? So if a classified document gets leaked, it doesn't stop being classified in and of itself, which means that you can't use as a defense, right? You can't use as a defense, well, I leaked the classified information. Of course I did. But that particular classified information was already leaked in the public. So no harm, no foul, right? You can't do that, right? You can't do that, right? You have an independent obligation to keep the information secret, regardless of what anyone else in the world does. So, hey, the information's already known, speaks nothing to your duty, right? Your duty is to keep it secret. So even assuming these particular images were leaked, which I'm not sure is true, incidentally, I'm not sure it's true. But even assuming they were, I really don't think it speaks to the issue because he had a duty and he fucked it up. Okay? So that's sort of where I'm like, he had a duty and he fucked it up. All right. Now, these are the two big allegations against this attorney, right? These two things, which neither one is great, to be sure. Now, the judge had indicated during a phone conference, which phone conferences aren't unusual. They happen all the time in trial. And it was unrecorded, which is not atypical. There's no transcript, which is also not atypical, right? Because different kinds of proceedings have different kinds of formality. So it would not be unusual to have a phone conversation with the judge and there's no transcript and no recording of it. But apparently during this phone call, it has been said that the judge indicated to the attorneys, both of them, that she was potentially interested in throwing them off the case, disqualifying them. The prosecutor's office filed a motion, I believe, to disqualify them. Okay? Now, the judge ordered a status hearing, which a status hearing is like, let's just figure out where we are, right? That's like where we are. And so it's a status hearing to discuss whatever they said. There was some specific issue. I forget what they said. I can't remember. So it's a status hearing to discuss this thing and other outstanding issues, right? And the thing that they identified was not the disqualification, right? It's an issue to discuss whatever, which isn't the disqualification, and other outstanding issues, which to my mind is nothing like notification that, we're going to discuss disqualification now. That's nothing like that. Because because the prosecutor had filed a motion, but they hadn't filed a response. They hadn't been asked for a response. So there'd be no way for them to know this hearing was for that purpose. Okay? So they show up to discuss whatever, and there is a recording of the meeting that happened in the judge's chambers. Okay, so we have that on transcript. So the judge brings them in to discuss whatever, and that part is basically like very brief, right? Because that isn't real reason we're here, right? So like 5 pages in, we've moved on to the next exciting topic. Let's talk about your disqualification. And the judge says, okay, I'm raising this issue sua sponte, which means she's doing it on her own motion, right? So this is literally now the very first time the attorneys have heard about this, because they had no notice. They had no notice, right? The judge had talked about the possibility maybe during a call. The state had filed a motion of thinking about it or contemplating it. But this judge is like, okay, I'm doing it sua sponte. This is literally the first time I'm telling you about it. And also, incidentally, I've made up my mind, because she made that clear, right? So she goes through these fuck-ups. And says, okay, you did the email with the index. You did the email with the table of contents thing. And you did the crime scene photos got leaked to the public thing. And I have questions about your competence as a result of that. Okay. And she's like, okay, so I want to disqualify you. And then she says, I am disqualifying you, right? It's like, this is a thing that's happening now, right? There's no discussion, no debate. There's really no hearing of any kind. And even if you could view it as a hearing, it's a hearing without notice, right? The judge hasn't in advance because the judge can do things sua sponte. They surely can. But normally you do it like in an order, right? Like, okay, order relating to this. The judge now sua sponte hereby wants a hearing on this subject. Here are the issues the judge wants to discuss. Please be prepared to discuss these issues at so-and-so time, right? You don't spring it on them. And even if you do it orally, you don't then have the hearing right away, right? So then you'd be like, okay, I just let you know I'm doing this sua sponte, so we need to schedule a time to do this, right? So that you guys can prepare. She's like, I'm doing sua sponte and I'm doing it right now. No notification, nothing, right? It's like, I'm doing it right now, and also I've decided I'm kicking you off. And so the judge basically says, the judge literally says, I'm paraphrasing, so I am paraphrasing, but this is what the judge says. She says, we can do this the easy way or the hard way. The easy way is you guys resign now in my chambers and slink off into the sunset. The hard way is we go into open court and we do this on the record. In open court, in front of, everyone, and I embarrass the shit out of you, before the entire bar, your client, and possibly the jury pool, right? So would you like to do this easy way or the hard way? So their attorney's like, okay, so you're saying that you're going to do this no matter what we do? She's like, I sure am. Okay, so then the attorneys, perhaps in a misstep, decide to resign. And we've discussed why, because it might waive the issue. And we don't know that it doesn't, because we'll get into what the Supreme Court is discussing later, because they're kind of dealing with all this stuff, right? So it might waive the issue because they resigned. But as one of the justices today did, they sort of resigned under duress, right? Because we're going to do this in open court. I'm going to beat you to death and tell you what horrible, horrible attorneys you are, not only prejudicing your client, not only prejudicing this case, but prejudicing you guys. And these guys were like, well, we're attorneys. We want to make a living. So we prefer not to be bashed in open court. And also, we don't think it's in our client's interests, because we don't think bashing him, we think that bashing their attorneys in open court is going to be a bad look for him and might read onto him. So for these twin reasons, it's bad for us and it's bad for the client. We choose to resign. So they resign, right? One of them does it in writing. One of them says they'll do it in writing, but then doesn't. But as far as my money's concerned, they resigned. Like they said it orally, I'm good, right? So yeah, someone was arguing with me in chat. Well, they didn't really resign because they didn't put it in writing. I'm like, they resigned. They said it. It counts, all right? So anyways, this is now the issue. So the judge kicked the two public defenders off the case for incompetency, for being very, very bad lawyers. So the lawyers, the kicked off lawyers, attempt to re-enter the case. They file a notice of appearance and be like, hey, now we're acting privately. You know, we're not acting as public defenders anymore. We're acting privately. And because this state seems to be one, at least that in part, appoints private attorneys to be public attorneys, right? So states can do this different ways, right? Some states have a public defender's office and there's dedicated attorneys like there is for the prosecutor. So there's dedicated attorneys that work in a public defender's office. Some states use more private attorneys. Sometimes there's a mix between the two. So at least in this particular case, for whatever confluence of reasons, I can't say. But these are private attorneys that are public defenders. Okay, we brought them in to be public defenders. Now we kick them off. It's like, well, we're still private attorneys. You know, we're still private attorneys. You can't take that away from us. So instead of us being appointed by the court, you know, and you revoking our charter that way, we now have a letter from the client saying he'd like to hire us pro bono. We'll do it for free. We're ready to go. We're ready to do this case. We're prepped. We're ready to go. Our client wants to have their case heard. This case has been going on long enough. They're ready to go. We're ready to present this thing. And we don't want delay. The trial court refuses to enter the notice of appearance because, of course, they aren't attorneys anymore. So in this case, she refuses to enter the notice of appearance on the record, which is a pretty spiteful move. Then also, the trial judge fails to make a copy of the transcript of the hearing that occurred in chambers available to the lawyers, right? The lawyers would like to protest this. Like, this is not fair. So the lawyers are like, can we get a copy of the transcript of the hearing, you know, that occurred in your chambers? And the judge is like, no, you can't get a copy. And every lawyer goes like, what the fuck? Obviously, this concerns me. I was there, right? This impacts me. What do you mean I can't have a copy? So previously on a previous edition of Dragon Ball Z, we've already gone to the state Supreme Court for an order for the transcript. Okay? And the clerk of court of the trial court, apparently sniffing their boss's fart, the trial judge, apparently commented that the state Supreme Court can't order the trial court to produce the transcript. The clerk of court of the trial court said the state Supreme Court can't order the trial court to produce the transcript. The Supreme Court of the state disagrees and ordered the release of the transcript, which was then produced. But it took that to get the transcript, okay? Just to show you how this judge is, all right, on this. All right, so we filed a writ of mandamus, right? We didn't appeal. We didn't appeal any of this. We filed a writ of mandamus, which is what they're talking about, like an original action, right? A writ of mandamus is just a writ to mandate. Do your job. It's literally a writ. A writ just means order. Mandamus means mandate. It's an order to mandate. Do your job, right? It's literally a do your job letter. Hey, we're a higher authority. You're not doing your job. Do your job. It's a fairly large embarrassment to the court below or the authority below, as the case may be, because it doesn't necessarily have to be a judge getting the order. In fact, typically it's not. Typically, writs of mandamus are to some administrative official somewhere. Some admin official in the exec branch isn't doing their job. So typically, to the extent writs of mandamus occur, they're typically yelling at the executive branch. So it's a little unusual to get it. It's in fact very unusual to get as a judge, and it's actually kind of insulting. I think it's actually substantially more insulting than being reversed on appeal. Because like, you're doing your job so badly, we have to intervene before the appeal, because we've never appealed because the guy hasn't been convicted. We haven't had a trial, right? So there's no appeal. So we have to intervene in the middle of this thing. And we also have to skip a step by skipping the Intermediate Court of Appeals and going straight to the Supreme Court of the state is how pissed we are, right? So I was like, I don't think they're going to grant the writ. I don't think they're going to grant the writ. That was my view, because I sort of agreed with, I think it was the counsel, I assume, for the judge, who said, well, this could be handled in a different way. Like, it seemed to me that the attorneys could have appealed to the appellate division, and there was an avenue there, and writs of mandamus are kind of like if you have no other options. So I thought they wouldn't grant the writ. But of course, I was wrong, because we just saw them literally grant the writ, because that's what just happened just now. Well, they granted the oral argument for the writ, more strictly speaking. So they haven't. They granted a hearing on the writ of mandamus, right? And to that. So that's sort of where we are now. The lawyer for Allen, the suspect, the lawyer for Allen, the suspect, gets up and he tries to argue this, and I think he goes about it totally the wrong way. He argues the court was out of its jurisdiction, which is just wrong. It's just wrong. The problem isn't jurisdiction. The problem is authority. And one of the other justices tried to correct him on the issue, and he's like, no, it's jurisdiction. I'm like, it's really not. Jurisdiction is fundamentally your power to hear the case. Right? That's jurisdiction. Do you have power to hear this question? She has power to hear the question. But namely the case against Allen, can she hear the murder case? Does she have power to adjudicate the murder case? That's jurisdiction. Yes, she does. She clearly has jurisdiction. And he's like, well, she exceeded her jurisdiction. I'm like, no, she didn't. She didn't exceed her jurisdiction. No, she exceeded her authority. Because just because you have power to hear the case doesn't mean you have power to do everything with respect to it, right? Just because you have the power to be a referee of a game doesn't mean you can just do whatever the hell you want. There are like still rules and stuff, right? So it conflates authority with power. My authority to do something and my power once I am in that domain are sort of not necessarily the same thing. But he says it's jurisdiction, and I'm like, you're already on the wrong path. And he also says, according to the relevant case law, which he cited in his brief. So I read his brief, and I didn't really find it particularly convincing in his brief either. Right? He says that the trial judges in this state, at least, in the great state of Indiana, right? Trial judges can only remove counsel for a very select list of reasons. And these aren't those. And the list is really narrow. It's exceptionally narrow. Like conflicts of interest, and I forget what else is on the list. It's a very, very small list. None of which applies to this situation. That much I'm sure of. Right? So unless it's one of these like 3 very specific narrow reasons, she can't do it. And I'm like, I don't think that's true. I don't think that's true. I mean, I know you keep saying it in your brief. I know you keep writing this, and I know you cited these cases, but I'm like, I don't think that's true. I don't think it can be that limited. That doesn't make sense to me. Now, in rebuttal, he sort of came back and made the argument in a way that sort of made sense, at least, which he didn't really do in his briefing or in the opening of his thing. He said, effectively, she can't do it because everything else is waivable. Oh, okay. Everything else is waivable. So the reason the judge can't do it any other way, the reason the judge can't do any except these 3 really narrow things is because they are definitionally non-waivable. Right? So that the client can't consent. They are non-waivable, such as a conflict of interest, an actual conflict of interest, non-waivable. So she can only do things for non-waivable reasons. She can't do things for waivable reasons. All right, so that's better. That's better. I still don't think that's right, though. Because you can just imagine there might be reasons the judge wants to kick the attorney off the case for reasons that don't necessarily have anything specifically to do with the client. Like maybe the attorney is just being a jackass, condescending, whatever, and you keep throwing him in contempt and nothing seems to work, and you're like, I just can't work with this guy. Or he's being loud, obnoxious, boorish, or otherwise, just disrespectful, and is calling down your fire. And it's like, this is too prejudicial because I'm going to keep having to do this through the trial. I'm going to keep having to do this and keep having to reprimand you, and that's going to really look bad. So, like, there might be a number of reasons the judge might want to kick a lawyer off, and it can't just be for waivable reasons. So the lawyer's theory is that the judge has an absolute duty, which is non-qualified, right? She has an absolute duty to let his choice of lawyer be lawyer. And I'm like, that can't be right. That can't be right, right? It can't be the case that it's an absolute duty, except for these small exceptions, right? It can't be absolute except for these small exceptions. That doesn't seem right to me. So I think this was the wrong way to go about arguing it, because I don't think it's necessary or required. You know, I think a much better way of going about it is simply due process, both as it respects to the lawyers themselves and also the client, because the failure to give process is a prejudice also to the client, because by kicking them off in a non-processed way, it hurts the client by delaying trial, requiring new counsel, delaying things, right? So there's prejudice to the client. So I think the easier way to go about this is due process. First of all, we have a due process interest in it as lawyers because, you know, professional reputation and all the rest of it. So we have a due process issue. And second of all, our client has a due process issue, and he violated both for all the reasons we talked about, right? You never gave us notice. Thank you for the $50, Amy. That's really, really generous. Thank you so much for the donation. I really, really appreciate your $50. Thank you so very much. Every donation matters, and I really appreciate it. All right. So I think the better way to go about it is due process, both substantive and procedural, right? Our client has substantive rights, such as speedy trial. He has procedural rights. He has an interest in not having this trial unduly delayed. His current lawyers are ready to go. Like the trial was supposed to be, I forget, it was supposed to be like 4 weeks or 6 weeks after this hearing, right? So it was supposed to happen relatively quick from the time of the hearing. And they're like, we're ready to go. We're ready to go. It's going to take another lawyer, you know, a year and change to get up to speed on this, minimum. You know? And the client knows. We've told the client, as he said in the letter that he read, right? But he's framing it as absolute duty. So the judge has no discretion. I don't think the Supreme Court is buying this based on their body language. I don't think the Supreme Court is buying this. Because it's like, that can't be right. It can't be right. Like, judges have they have the right to control their courtroom. And they also have an interest in protecting the right of the clients, perhaps even against his own predilections. So perhaps even to protect himself, they might have a role to step in. So I'm not sure about the non-waivable thing, but at least you're closer. Maybe that makes sense. Maybe the client can give knowing informed consent about the waivable things. But as it speaks to, but the issues that are at play, at least partially, don't speak to just issues against the client, right? The failure to keep information under control is also a violation of the court's order. So not only does it serve as prejudice to the client, it serves as prejudice to the court, which arguably gives the court some basis to discipline the attorneys, but probably not kick them off the case. And certainly not the way they went about it, right? Certainly not the way they went about it. So I would have argued that, you know, and argued that the judge made a mistake in, you know, it was clear error. I know clear error is hard. Clear error is a hard standard, but I think I can make the hurdle. The judge was a clear error. This is a violation of substantive due process, procedural due process, and the judge is in clear error. That's how I'd go about it. And clear error is hard, but I think I can make it. All right. So anyways, so they argue with that guy for a while about it and ask him a whole bunch of questions about a whole bunch of things. And his answers are like, not great. Thank you, Lars, as well, for the €11.99. I really appreciate your donations. Everyone who helps to support the channel really does make a difference. You guys are helping to pay my taxes and also helping to pay my moving expenses because I'm moving soon. So I do appreciate that. Also, you're helping to celebrate my birthday, which was 5 days ago. So many reasons to donate, and I appreciate it all. So anyways, they beat him to death for a while, and a lot of his answers are like not great. And they ask him questions, and he tries to like mealy mouth it and tries to have his cake and eat it too. And I'm like, no. Because the judges are like basically at one point, so if we give you what you want, is your client waiving ineffective assistance of counsel? The answer to this is clearly yes, by the way. It's unambiguously yes. because the basis for the judge's actions is at least partially ineffective assistance of counsel. I'm concerned that you're ineffective. And so, like, okay, if I overrule the judge and make them do that, aren't you waiving the issue? And he gives this long, rambling, meandering answer when the answer would just be yes, he would be, assuming he does so at the end of a proper hearing. He takes like 8 sentences to say something vaguely resembling that. Thank you, Bravo Chick, for the $5 for happy belated birthday. I appreciate that. I am moving to Houston from Austin. And I'm moving to be closer to Nate the lawyer and attorney Tom, on the hope that being nearer to them will help promote synergy between our channels and help us to grow. So, plus I don't have any particular reason to stay here in Austin. So yeah, I'm moving to Houston to try to be closer to my friends. And also, why not? Why not try something else now? Something new. But yeah, anyways. So then, so they beat the lawyer. They beat the lawyer for Richard Allen to death for a while. And then the state gets up and they start to beat her to death for a while, or him to death for a while, because, like, how is this fair? How is this due process? How did they get enough hearing? It's like, it was fair. It was good. They got enough. You know, it was okay. Now, I think they're right. I think that the opposition is correct. That is not limited to the situations. I don't think it's as narrow as Richard Allen's attorneys want it to be. I think the judge can act further than that. But even if the judge can act further than that, she still has to go about it in a proper way. And I say she because the trial judge was a she in this case. So she has to go about it in a proper way, and this ain't it. First of all, I'm not sure you had enough to do it in the first place, like as your first thing, right? Because normally when we talk about sanctions in any sort of context, we're talking about escalating sanctions. Sanctions are kind of like a crime in some way, right? How much do you get punished for a crime? Well, you get punished more the more crimes you do, right? So the more crimes you have records of doing, the more we're going to punish you for this crime because you haven't gotten the memo yet. So the 5 prior crimes are going to hurt you as to this crime, right? So the first time we'll probably give you a break. The 5th time, probably not as much, right? So that's one way we do it. And the other way we do it is by severity. How bad is it? So if the first time, you stab a guy, that it's your first time, we're probably not going to give you much of a break, right? So sanctions are kind of the same way. How bad have you been, and how bad is this thing? So at least in my humble opinion, I don't think that the attorneys have been particularly bad, and I don't think that what they did was at this level. I wouldn't necessarily object to the judge sanctioning them in some way, but I think she went a little bit far, and I'd actually argue for clear error. I think she went far, or actually technically abuse of discretion at that point, so I'd argue both. Clear error as to facts and abuse of discretion. I can argue both. So I'd argue, yeah, she was in clear error as to the findings of fact, and she's abused discretion because she went and did too much with what she had. So I'm basically criticizing the judge every possible way I can at this point, which, fine enough, but I think it's there. So anyway, they tried to convince the judge that, that the process was fine, and the courts weren't really buying that, and the justices beat them up to death for a while. And then the Attorney General's office got up, and I'm not sure what they said, to be honest. I was listening to her say things, and it just sounded like a random collection of buzzwords. I didn't really get anything out of it. So I'm not sure what the Attorney General's office was trying to do, other than say we're concerned if this court acts, that it will open the door towards more people asking this court to act, and this court is already burdened enough as it is. And one of the justices I do appreciate your concern for our docket, lol. But as long as we're here anyway, right? And then there's also this question of, like, should we get to the merits of something, right? So to get past the process of the thing, right? So should we actually go to the merits of whether a judge was right, which goes to, like, the clear error and abuse of discretion issues, which is an issue of first impression, right? There's nothing on the record below, because nothing happened below, because the judge went about it in a completely weird way, right? There's no record because the judge didn't create one, because there was really no hearing. There was an in-camera hearing that there was no notice of. So they're like, well, this is a case of first impression, which they don't strictly mean that. Because a case of first impression is what typically you mean a legal issue, and I'm pretty sure that's not what they meant. I'm pretty sure what they meant was this is something that the trial court didn't decide. There is no lower court that has decided this issue, and we'd have to decide it now for the first time, which isn't typically something the Supreme Court does, right? The Supreme Court isn't normally the one who is the first one to decide something. Usually they are affirming or denying what happened below, not just doing it, except, of course, to the extent they have original jurisdiction, which this technically is. So it's like, should we actually get to the merits of the thing and speak to that as long as we're here? So that's sort of where we wound. And then finally, Richard Allen's attorney got up and gave a much more impressive rebuttal. So fortunately, he showed up for the last 7 minutes of this thing. He's like, well, the Attorney General's office has lied and said that we don't know what the client wanted. He just literally quotes the letter, which I thought was pretty badass. And the justice is like, well, we have the letter. I'm like, yeah, but I just read it all in the record. So, booyah. And then said basically the more understandable idea that this is waivable. So rather than mealy mouthing around the issue, he answered the question that was asked to him like 30 minutes ago and said, yes, this is waivable after a sufficient hearing where the client is advised this is waivable, and he would waive the issue of ineffective assistance of counsel with respect to that, which seems like the correct answer. And therefore, implicitly, although I don't think he said it explicitly, therefore, because the client can waive it, the judge can't overrule him for that reason, right? If the issue is ineffective assistance of counsel, if that's the issue, as opposed to the lawyer being belligerent or disrespectful to the court or something impacting the court, if the issue is the concern to the client and the client can waive it, then the client can waive it, and this judge can't act unilaterally. All she can do is ask, are you really, really sure? And that's all she can do. So that makes a lot more sense as an idea. So yeah, now I'm like I wish you had clarified that earlier, because that makes a lot more sense. But he was talking about absolute duty, right? Absolute duty. And like, it's the judge's absolute duty, except not to dismiss in these limited circumstances. I'm like, eh. And then he's talking about jurisdiction. I'm like, that's definitely not the right thing. So what kind of sanctions could she give? I mean, money's the most obvious thing. Money's the most obvious thing. Hurt them in the pocketbook is usually a good way to get their attention. So, So that's sort of what happened at the hearing. So hopefully that summarizes all that in an understandable way. Thank you for the 770 of you who are currently here. We appreciate you being here. Let me see if there's any other questions. Yeah. Is there an argument for him not to waive ineffective assistance on other issues? Yes. I think that's right. So it would only be waiving ineffective assistance of counsel for that reason, because that's the reason that she would be dismissing him, not other reasons. So yeah. Possibly. There's also 10 of you on Twitch. Awesome. Appreciate that as well. Monetary even when appointed? Oh, sure. Absolutely. Yeah. Of course. Yeah. It's coming out of your pocket, baby. Oh, yeah. Even if you're pro bono. Sure, yeah. I'm still going to fine you. I'm not being paid. Well, that's a you problem. Lol. Yeah. No problem. Kurt getting a smoker for his new place? No smoker. I don't need it. I'm just reading through your past comments to see if there are any questions before I sign off. So I think that the Supreme Court, having heard all this, is going to reverse the trial judge some way. I'm not sure exactly how, but I think also the Supreme Court is a little bit irritated with the trial judge because of like the earlier defiance and things. And I think the Supreme Court wants to smack the trial judge around a little. So my expectation is they will grant the writ. And then what they'll do after that, at that point, I don't know. And this whole speedy trial argument was insane because they never filed it, right? Oh, well, he signed it, but he never filed it. You never asked the court. So the Supreme Court's like, you want a speedy trial, but you never asked. well, it was signed, but you never filed it, right? So it's like, oh my God. So it's like, yeah, I expect that they're going to reverse, possibly appoint it to a new judge, which is also pretty insulting, and say if you want a speedy trial, you can refile for that, and let's move on. So that's what I think. I think they're going to reverse and probably boot her. Yeah, I think they're going to reverse and probably boot her. That would be my expectation. I mean, removing the judge is a pretty big insult too. I mean, a writ of mandamus is insulting enough, and then you get a remove, then you get this taken off your docket too. Woof, woof. Can they remove the judge? Sure, they're the Supreme Court. They can do whatever the hell they want. Yeah, sure they can. Can he get moved to jail and out of prison? I can't speak to those issues. Right. So it is atypical, although not unheard of, for people awaiting trial to be in prison. I mean, typically they're there because they're already in prison in the first place. But it is not unheard of, although it's very unusual for a person awaiting trial to be in prison, which he is. So I can't speak to that. I seriously doubt the Supreme Court's going to speak to that now either. Yeah. Am I covering Treehouse today? No, I'm not covering Treehouse today. I'll be doing my stream later today with the Thursday Night Thunderdome, so I'm looking forward to that. And I've got to film some stuff when I stop talking to you, because I've been delaying it. I got to get it done for Attorneys React. Is there any other questions I can answer right now? But I definitely think they're going to reprimand the judge. I think they're going to reprimand the judge. Because, like, we're already here. We're already here, so why not, I had a very good stream yesterday, for those of you who want to tune in. We had a 5-hour stream yesterday, which was a lengthy stream. We spent the first 2 hours or so breaking down a conversation I had with Destiny, who is a major streamer, multimillionaire, major streamer. I'm jealous, but that's okay. We had a good discussion, Destiny and I. And then we had a 3-hour discussion or so, which was unexpected, with this attorney named Pisco, who was very mean to me in Destiny's chat, and he apologizes for being mean to me. Wherein we discussed January 6th and whether it was an insurrection or not. And we also discussed the kicking of Trump off the ballot in Colorado and whether that was legal or not. And we had a very good discussion. I enjoyed it. And as always, you should hit the like button, of course. So I hope to have further discussions with him in the future about things, because he certainly made me think about things, and I appreciate that. Is this how many Supreme Court judges are in the Supreme Court? Depends on states. Just depends on the state. Different states have different numbers. There's no set number. The Supreme Court apparently is 5 for some reason. Texas is so great. We have 2 Supreme Courts. Like Oklahoma. So nice we did it twice. We have 1 for civil law and 1 for criminal law for some reason. And then, of course, just to confuse everyone, New York calls theirs the New York Court of Appeals because they want to confuse you. They have a Supreme Court too, but their Supreme Court is the trial level court in New York. They just want to confuse everybody. And you'll find news articles make that mistake a lot. They'll make that mistake a lot. They'll say so and so of the New York Supreme Court, the justice wrote, and I'm like, no, it's judge, because they're the trial court. So they make that mistake. When will decisions come out? Who knows? I wouldn't expect too long, but they didn't give a firm time. I'd expect relatively soon. So I'd expect within the next week or two. 712 watching and only 236 likes. That does seem like a low ratio. We could up the like ratio better. 500 if you haven't licked the like button yet. That'd be good. What else? I'm having fun talking with you. Yeah. We're still at 373 likes. Yeah, we do have room to grow. All right, well, if there's nothing further for me, then I'll go ahead and sign off. Let me see if there's somewhere I can redirect you to, because I do like to do that when I can. Let's see if anyone else is streaming. I can send you their way as a courtesy. Let's see. I'll send you Recovery Addict's way. Oh, Donnie on Direct is also streaming. I'll send you Donnie on Direct's way. She needs a little bit more love, so I'll give her the redirect. I wish it wasn't so hard to set up in YouTube. After the defendant waived a preliminary hearing, with respect to what case? I don't know. I don't know the history of every case cold. It's a lot to keep in your head. All right. We're done here, guys. You know the drill. When you go to Donnie On's channel, be nice, say hi, be respectful. I've had fun. I'll talk to you later. Till later, my friends, I hope all's well. Cheers, my friends, and goodbye.